So you know when Uber lawyers, Uber attorneys are getting desperate, right? So their whole new legal strategy, Uber's new legal strategy is that the riders employ drivers. We don't employ the drivers. The riders employ the drivers. This is what this attorney who has his head up his ass is telling a judge in court. Let's read it. It's too funny. It's laughable. You see, this is the caliber of attorney they hire, right? Anything to bypass, fudge, misclassify, and not comply with the law. And this is another attorney, mark my words, I'm going to call his name out, that I will be filing a complaint to with the State Bar of California, because it's attorneys or lawyers like this that are harming the hard-working gig worker. So here we go. This is so beyond laughable. San Francisco, an Uber lawyer on Wednesday previewed the company's new legal strategy for keeping drivers classified as non-employee contractors, despite a new California labor law that makes it harder to do so. Last year, California passed Assembly Bill 5, we know that, AB 5, which requires companies to classify workers as employees unless they perform work that is outside the usual course of the hiring entity's business. During a video conference, listen to this, of a lawsuit seeking sick pay for Uber drivers in California, Uber lawyer Thean Evangelis, I'm going to look him up, and I'm going to make a separate video about you, Thean Evangelis, because you truly have your head up your arsehole, right? That's where your head is stuck right now, in your arsehole. Said the new state labor law does not apply to her client because Uber does not hire drivers. Uber does not hire drivers. So who would be hiring the entity? U.S. District Judge Edward Chen asked, right? Judge asked a legitimate question. And then the answer, the individual consumer who asks for a ride, Evangelis replied. It's not Uber who is hiring the drivers to perform services for Uber. It's the individual consumer who asks for a ride. Their classic game plan, as other people in this world do, blame others. Deflect. Not our problem. We didn't do this. They hired. We didn't do this, right? So don't take blame. Shift the blame onto someone else. This is how these guys operate from day one. Right? I call it the Travis Kalanick, Derek Kay sort of culture of the company. So reacting to the revelation of Uber's new legal tactics, Stanford law professor William Gould, the fourth, said in a phone interview that he believes Uber's positions are getting stranger and wilder. So Uber's position now, their desperation levels are getting stranger and wilder. There it is, right? This one is just completely ludicrous, Gould said. If I buy a ticket to get on a train, am I the employee of the conductor or the ticket agent? Exactly, right? Evangelis also revealed Wednesday that Uber plans to demand discovery on whether two named plaintiffs in the lawsuit also drive for Uber's competitor Lyft. She said that will help establish if ride-hail platforms are hiring entities subject to California's stricter ABC test for determining a worker's employment status. Gould said he does not believe that evidence will help Uber in fighting the litigation. There are countless cases where employees work for a number of employers. Gould said that is the modern economy that we live in. That's true. At the hearing, Judge Chen appeared equally mystified as to how evidence that drivers work for Lyft and Uber will help the company prevail. Why does it matter if one of these plaintiffs does work for 2 or 3 different companies, the judge asks. Well, it shows whether these entities are hiring platforms or the extent to them being used simultaneously. Looking at the Uber app while on a ride they get from the Lyft platform, Evangelis said. It's why we think plaintiffs are not employees. Wow. I'd like to just pull his head out of his arsehole. Representing lead plaintiff and Uber driver Spencer Verhines, attorney Shannon Liss-Riordan blasted Uber's request for discovery as a delay tactic. Uber is clearly going to do everything it can to stall out a ruling on this in any way it can, Lyft's audience said. So that's one of the heavy hitters on the East Coast. And again, they're very, very good at delay tactics. Remember, I'm in the midst of trying to negotiate a settlement. And how do they play the delaying game? By not accepting the documentation, delivery refused by recipient, right? It was sent to Uber. They wanted to receive it. They wanted to get it. And what do? They know by denying FedEx or denying UPS again and again and again, it wins time. They're masters and masters at buying time, right? And the only way you get around it, and I've done this with 3 attorneys, is you file a complaint against the state bar and show that they are not complying with the law. They have no willingness to comply with the law. This is how they're set up, right? So Judge Chen on Wednesday also rejected the plaintiff's request to postpone ruling on arbitration issues, which could force most Uber drivers to pursue claims of labor violations through individual arbitration. That's exactly what I signed up with potterhandy.com. That's what you guys need to do if you're in California. Citing the judge's position and the fact that only a small number of Uber drivers have opted out of arbitration, this audience said her clients will dismiss class allegations and instead seek summary judgment on behalf of 2 named plaintiffs in the Verheins versus Uber case. Both named plaintiffs opted out of arbitration. Our summary judgment motion will rely on prong B. Lyft audience said, referring to the second part of the Assembly Bill 5's ABC test, which says a worker must perform work that is outside an employer's usual course of business in order to be classified as an independent contractor. In March, the plaintiffs filed an emergency motion for a preliminary injunction to make Uber reclassify drivers as employees and provide sick pay. Following an April 1 hearing, Judge Chen ordered both sides to start negotiating a deal to make it easier for drivers to access Uber's financial aid program for COVID-19. On Wednesday, both sides announced that a deal was reached. The plaintiffs withdrew their motion for an emergency injunction, but details of the settlement remain confidential. So there's some deal that they've struck, but that's obviously confidential. Also on Wednesday, Chen heard arguments in a related class action, Capriol versus Uber, which seeks an emergency injunction to make Uber provide sick pay to drivers in Massachusetts. The case was transferred from the District of Massachusetts on April the 1st. Chen again ordered both sides to negotiate a deal to expand access to Uber's sick pay type program for drivers in Massachusetts. Uber's attorney Evangelis said the company is willing to extend similar terms of the recently brokered deal for California drivers to Massachusetts. So they're buying time. They're doing everything that they can, but I find it laughable. I find it laughable of this attorney that he thinks that the riders are actually employing the riders are employing the drivers. And I say to Thean Evangelis, pull your head out of your arsehole.